Welcome to the next episode of Loan Risk Advisors Compliance Rundown. Today I want to talk about the Telephone Consumer Protection Act, or known as TCPA, and new requirements that they have in 2025. This is a quick rundown that focuses mostly on the one-to-one prior express written consent that we are now required to have before we can call certain borrowers. The goal here is to provide clarity on the particulars of this requirement and walk away with some high-level, quick understanding what this means and doesn't mean. What we are talking about here is a bucket of calls where we make calls or texts to mobile phones where in doing that, you're either using an autodialer or artificial voice. Now, a lot of companies will use autodialers or have at least an autodialer system to make their outbound calls once they get a lead from a lead generator. And that's kind of the underlying premise that at least I'm working off of here. Now, there are other requirements under TCPA about do not call and about residential numbers. Some things are old, some things are updated and new as well. I'm specifically talking about the prior express written consent required here for calling basically mobile phones. Now, I thought I would approach this by looking at some of the questions I've been getting on TCPA in 2025. So let's take a look at those questions. Okay. Now, question one, is there a change in 2025? Yes, there is. So here, as I mentioned, we're talking about the prior express written consent for specific calls. Like I said, mobile phones for the most part, and where the lender is using an auto dialer or something to that effect. The difference here now is the consent that we'll be using to make those calls, where lead generators got them before, now has to identify to whom the consent will go. Lead generators, or in generating leads, you can no longer leave it blind as to, yes, I give consent, but I don't know where it's going. No, we now have to identify where it's going, and that's the big difference. Now, let's look at question number 2. All right, so what is prior express written consent? All right. The term prior express written consent means an agreement in writing that bears the signature of the person called or texted that clearly and conspicuously authorizes no more than one identified seller to deliver or cause to be delivered to the person called or texted advertisements or telemarketing messages using an automatic telephone dialing system or an artificial or pre-recorded voice. Basically, what we're saying is we have prior express written consent, but this time you have to identify to whom that consent will go before the consumer will complete it or can't complete it. It's interesting also, it authorizes no more than one identified seller to deliver. Okay, so anyway, as it's written, it looks like you still have to identify the one seller. Let's look at question 3. Okay, so does this mean the lead generator is required to list only one possible seller or caller in the prior express written consent form? Okay, well, that's an interesting question, actually, because according to the FCC, when they rolled this out in this rule and in their logic, they specifically said, and let me see what it says, for instance, a website may offer a checkbox list that allows the consumer to choose each seller that they wish to hear from. Okay, so the FCC has opened the door to the idea of having multiple sellers possibly on there, and then the consumer checking the box as to which one the consent should go to. It even implies perhaps that it could be checking more than one particular seller. But that being said, that's still kind of in the air, but there is a possibility that you can show more than one seller the way the FCC is interpreting their own rule. But keep in mind, the consumer is still required to check the box. Put another way, if you got a consent and your box wasn't checked, you can't call them. That much we do know. Now, on to question 4. Does the consumer need to sign this? Yes, a signature is required, although any kind of signature compliant with the e-Sign Act and applicable state laws will be sufficient. So check with your legal or compliance professional to make sure how you comply with e-Sign and what documentation, etc. process you have to evidence that you've complied with e-Sign in doing this. Question number 5. What is proper disclosure language? Okay, you need language that states the consumer is authorizing the seller to calls or text using the automated telephone dialing system or artificial or pre-recorded voice. So again, we need the word consent. The consumer is consenting to this. You need language explaining the consumer is not required to sign the agreement or is required to enter such an agreement as a condition of purchasing any property, goods, or services. Okay, now keep in mind there's a disclosure language you have to have in there they have to see and read. This is a disclosure. So talk to your legal or compliance professional about electronic disclosures in compliance with the e-Sign Act and what that takes to make sure the disclosure is proper. Remember, disclosures are permitted electronically provided you comply with the certain provisions of the e-Sign Act. Okay, let's move on to question 6. Once I have this prior express written consent, can I reach out to the consumer for any purpose? Not really. If you have the consent, you can use the consent for the purpose the consumer gave it to you. So if the consumer was looking for a mortgage loan, then you can call them on a mortgage loan. If they gave you consent for a mortgage loan and you want to talk to them about auto loans or unsecured loans, cannot do that. It's got to stay within the lane in which the consent was given to begin with. Let's move on to the next question. Question 7. What happens if I mistakenly call someone where I cannot show I had prior express written consent? Okay. Now, per TCPA, the consumer may have a private right of action against your company for $500 per violation. Keep in mind there's no gimmies or mulligans where you can call someone accidentally and still be okay. So theoretically, maybe the first call where you don't have consent is a violation. Also, and this is important, the fact that the consent wasn't properly captured or shared with your company by a lead generated company is not a defense. If you're going to make the call, you're responsible to make sure that you possess and have the information and evidence to show that you had the actual prior express written consent with proper disclosures properly signed before you can make that call. So what's the takeaway from this Loan Risk Advisors compliance rundown? Well, remember, the calls we're talking about are primarily those made to mobile phones where the company is using an autodialer or otherwise has the ability to use an autodialer. In that instance, you want to keep in mind these things. 1, make sure you have prior express written consent that identifies your company as the one permitted to call that consumer. 2, make sure that consent is actually properly signed. 3, make sure your lead gen company has used all the right language in the consent. 4, make sure the agreement with your lead gen company assures you that they will be compliant with this requirement and of course many other requirements as well. Well, that's pretty much it for this compliance rundown for this portion of TCPA. I look forward to seeing you at the next Loan Risk Advisors Compliance Rundown.